Hello and welcome to Medina McKelvey's webinar of all the updates of 2024 that impact California employers. I'm just going to give everyone a minute or so to filter in from the waiting room, and then we'll get started with my colleague Asha and myself, Chantelle Egan. Hello, welcome all. My name is Chantelle Egan. I'm a partner here at Medina McKelvey. I head up our advice and counsel department, and I'm joined here today by my colleague Asha Lopez. And today we're going to be walking through some of the new additions that are coming your way in 2024. That are impacting California employers within employment law. We're also going to spend some time today really flagging for you what are those things that are going to really impact policies that you have in place, as well as practices. And so that you're hopefully at the end of this webinar will feel armed with the knowledge that you need in order to tackle 2024 new compliance successfully. A little bit about my colleague Asha. Asha is just joined Medina McKelvey. We are so thrilled to have her. She has been an attorney for 7 years. She actually started her career in the California state capitol, drafting bills and lobbying bills. So if you're upset with any of these new laws, though, you don't need to blame her for these ones. She's since moved on and has been an employment litigator for the last 3 years. And we're so happy to have her with us. And today she's going to be talking about some of these additions as well as myself. So let's get right into it in terms of what it is that is changing, because there's quite a bit that we're going to be covering. As we go through this presentation, feel free to use the Q&A function to post any questions that you may have. We'll do our best to answer the questions. Some of them we may be able to tackle live, as well as both Asha and I are willing to stay on for a little bit after the webinar to go through some of these questions. And then, of course, if we run out of time, we'll circle back with you so that we make sure that all your questions are answered. So once again, use the Q&A function, not the chat. It can be a little bit confusing because we are in Zoom, so use the Q&A function. Thank you for that. So one of the big changes in 2024 is an increase in paid sick leave. So for ages, we've been looking at 3 days as our paid sick leave window on an annual basis. Well, starting January 1, those numbers increase. And so on an annual basis, it is now 40 hours or 5 days of paid sick leave. Importantly, as the law is drafted, it could be interpreted that 40 hours versus 5 days, it's a whichever is greater. So if you have somebody, for example, that's typically working a 10-hour shift, their 5 days is going to be longer than 40 hours, and you should be providing them that greater amount. Additionally, for those of you that are adopting the traditional accrual method, which is 1 hour for every 30 hours work, luckily that hasn't changed. It's going to be, the cap is going to be increased. So now that threshold at which point an employee stops accruing paid sick leave will be 80 hours or 10 days. And that's up from 48 hours and 6 days. And this is an important change because for those of you that are doing accrual as your as the methodology that you're using, and I would say most employers are, for those of you that are also tackling local ordinances such as San Francisco, Santa Monica, there's a plethora of them throughout the state. This cap threshold is more generous than any of those local ordinances. So if you are complying with state law and having the threshold be 80 hours, 10 days, that means that you are by default complying with the local ordinance. And I want to emphasize that that's a little bit different, though, if you're front loading. So under the state law, If you're front loading, then you're going to be doing 40 hours and 5 days. In essence, this is how much is a permissible use in the year. So if you're front loading, and for those of you that need a reminder of what that means, that is, instead of doing a traditional accrual method, you just say, all right, it's the beginning of the year, and that could be January 1, that could be another 12-month cycle that you adopt. You say, I'm just giving you all the sick leave that is permissible for you to use during the year, and I'm giving it to you at the front of the year. And you have all year with the ability to use it. However, at the start of the next year, it doesn't carry over. You just get a new front-loaded amount. For those of you that are balancing local jurisdictions, this front-loading method may not check all the boxes for you. So for example, Santa Monica has a 72-hour requirement. So if you're front-loading and you're in Santa Monica, you still need to comply with that local ordinance. So even though this does, include some preemptions with local ordinances that are actually baked into the law, as well as just as a practical matter, that there tends to be that hopefully we'll have a more universal practice here throughout the state. For those of you that are using front load methodology, then you need to be very cognizant of what the local ordinance is and whether or not you're actually complying with both the state and the local requirement. Additionally, it's worthwhile to mention that if you're using an alternative accrual method, so you're still doing accrual, but you're not doing 1 hour for every 30 hours worked, then there's certain thresholds that have to be met as for new employees. And in particular, when you have a new employee by the 120th day, then they need to have 24 hours of sick in their bank. And by the 200th day, they need 40 hours. Importantly, this is a calendar day, not a working day. So you have somebody that's working, let's say, part-time, they're only working a couple days a week. When we're looking at these thresholds, we're looking at all the days in the year that they're not working as well in order to meet those thresholds. So as a general matter, as like a pro tip, it's typically easier if you're using an accrual method to stick with the 1 hour for every 30 hours work. And we just got a question about, a variable schedule. We probably are going to get some guidance from the state on how to handle this. I think the key thing here is to be as generous as possible. And the threshold is that they were supposed to be receiving whatever gives them the most amount of paid sick days off. So that should be your guiding post. And so the key thing here too is if you have somebody with a really short week, so let's say you have somebody working 4 days a week, or they're working 2 days a week, that they still have a 40-hour threshold, even though maybe their typical days, or they typically work a short day of 4 hours in a day, they're going to still have a 40-hour threshold as if they're working a traditional full-time schedule. All right, so I'm just marking some of my. And then if we move over towards reproductive loss. So some of you may remember from last year that we have a new bereavement leave. This is really an extension of that bereavement leave. It's really kind of, in some ways, I mean, there's so many similarities between the law in terms of the availability of the time, and it really is kind of almost a nod to the fact that those individuals that are experiencing reproductive loss, that they too need time off to potentially grieve. So the spirit of the law is very similar, but there's some intrinsic differences that I want to walk you through. So for those of you that have at least 5 employees, this law is triggered. And what this means was when someone experiences a reproductive loss, they can take 5 days off. And these days do not need to be in a row. And but they must be taken within 3 months of the event. Or for folks that had a related leave, and I'll kind of walk through that in a second, taken after 3 months after that. And this time off would be unpaid. So first, let's talk about what reproductive loss is. It's actually a very, very kind of large umbrella. So, we have miscarriage or things of that nature. But it also applies in the example of a failed surrogacy. So that's everything from a dissolution or a breach of a surrogacy contract or a failed embryo transfer to a surrogate. And this also applies to who would be the ultimate parent after the birth or after the child is provided to the family. So this is not something that is limited to the birth parent, but rather if you are a parent and the mother of your child experiences a loss and you're that partner and you would ultimately be the parent when a child is born, you're also going to be able to use this particular benefit or leave. And it also includes things that if you have a adoption and a failed adoption, that would be a reproductive loss, as well as if you have, in vitro or some other kind of assisted reproduction, and you have a unsuccessful embryo transfer, that's considered a loss. So, for example, if you are doing egg gathering in preparation for an embryo transfer, that's not going to be involved. But if the transfer itself is unsuccessful, then we have a reproductive loss that would trigger this law. And so part of the reason that when we talk about this 3-month window is that it has two potential start times. One, as I said earlier, is right when the event occurs. So let's look at like a miscarriage, for example. A miscarriage for a non-birth parent, that would start right at the time of the miscarriage. A miscarriage for the birth parent, there's a potential that that person that experienced the miscarriage may have other leave that they are eligible for first. So for example, perhaps there is some type of medical recovery that needs to happen and they need to be on disability leave. Then if that's the case, it's once their disability leave has expired, then at that point, the 3 months for them to take their reproductive loss leave, that 3-month is triggered. Another thing too to think about we have this very kind of broad definition of reproductive loss is that there could be a situation where an individual experiences more than one reproductive loss in a year. And in that particular situation, cumulatively, you can take up to 20 days. So as a practical matter, it means that you can really exercise about 4 reproductive loss events. You can exercise leave for 4 reproductive loss events in a 12-month span. Last but not least, because this is unpaid, people can use not only, vacation and PTO, but they also can use their eligible sick time, which, as we just talked about, has now increased. Another thing that's on the horizon is cannabis use and testing. Interestingly, this law was actually put on the books back in 2022. But we were given a really, really long runway for when it became effective. So this law becomes effective in January 1 of 2024. And as a big picture, look, this really is for those of you that are doing any type of drug testing. This is going to change the way that you can do drug testing. And in short, what it means is that when you are doing drug screening, the screening has to be designed to make sure that it's not testing for non-psychoactive cannabis in hair, blood, urine, and body fluids. So another way of thinking about this in really basic terms is, cannabis can stay in someone's system for a very long time, even after the effects of the drug have gone through their system. So your test needs to the extent you're using a test, it needs to make sure that it's not just testing if you have cannabis in your system generally, but that psychoactive nature of it, in essence, like the piece of it that makes you high, that is what is testing. Is this person high in the moment, in the most basic way of saying this? And additionally, it really carves out that while this has already been part of the law, that we need to now make sure that employers know that they can't discriminate against individuals that are engaging in off-duty use of cannabis or cannabis products. Because in essence, think of it as this way of like, it's cannabis is really now, due to the legality of it in California, kind of falling into that same camp as alcohol, as a way to kind of get your head around it. Likewise, when an employer is requesting information from a potential applicant, they can't talk about prior cannabis use. That is also restricted. So anytime that you're doing any kind of hiring, termination, or really changing any term and condition of employment, you need to ensure that somebody's off-duty cannabis use, assuming that that they're not experiencing the psychoactive nature of cannabis while they are at the workplace, is not something that is you're being tested for or you're making employment decisions on. As with this and with all the other things we've just talked about, this all requires handbook updates. So both paid sick, reproductive loss, and for those of you that have any kind of drug testing policies or practices, this certainly requires that you update your handbook to be in compliance, ideally prior to January 1. And if you can't do it January 1, being the law does go into effect, then I recommend that you do it as soon as possible. It is worth mentioning that the two things that need kind of a look-see other than your handbooks is really making sure that you are looking at your onboarding documents to ensure that there is nothing in there where you could be asking about someone's cannabis use. And in particular, in the onboarding documents, that second thing you need to look at is any kind of background check clearance materials that you have. Just make sure that it's in compliance with these updated laws. So in addition to your handbook, for this new law, we need to make sure that your onboarding documents are in good shape. There are exemptions to this. Not surprising, some of you may be, familiar with, DOT requirements. The big picture in terms of where these exemptions are is, not surprisingly, it's if there's a state or federal law regarding applicants or employees requiring them to be tested for drugs and have a more broad testing standard, then those laws, whether they are state or federal, will trump this particular cannabis use testing. And we really, the perfect example of that is, somebody who is in the trucking industry. And DOT has very strict laws about, spot checks and things like that. Additionally, those that are required to have any kind of federal background investigation or security clearance, they're also exempted from this law. And there is also a carve out for employees or the building or construction trades. And interestingly, this is an undefined term, what trades is. So for those of you that are in those particular industries, it's definitely worth talking to your lawyer about whether or not that applies to your entire workforce or just the folks that are performing, your carpenters, your plumbers, things of that nature, or they're actually doing the construction themselves, whether it just applies to them. That's going to be a risk assessment that you're going to want to talk to your lawyer about. So with that, I'm going to pass it over to Asha.
Hello. Okay, so I get the fun non-compete agreement. So, just as like the foundational root of like laws in California, just like related to non-compete agreements, is just that people should be able to freely engage in just legal employment opportunities. So with that, these new bills, SB 699 and AB 1076, they go a little bit further. They basically codify this even more significantly. SB 699 makes any contract with a non-compete provision null and void, regardless of where it was signed. This is significant because California, we already know, they have non-compete agreements that are already non-enforceable with few exceptions, but this instead is saying that regardless of where this agreement was originally signed, like in another state, it's no longer valid in California. So, for example, if you have an employee that signed a non-compete agreement in Mississippi and they later transfer to California, they are no longer beholden to the terms of the Mississippi agreement. While the non-compete agreement might have been enforceable in California, it is no longer valid in California by way of that employee relocating to California. AB 1076 also then requires an affirmative notification that previous non-compete agreement is no longer enforceable. So let's go back to that Mississippi employee. Like, not only is that provision no longer valid, but you as the employer have to inform the employee that the provision is no longer valid. So just kind of be aware that the failure to do so could result in a violation of California's unfair competition laws. We suggest that, like, if you're aware of an employee like relocating to California and you do have like this provision in an employee personnel file, that you document that the provision is void and no longer enforceable. I know that's hard because you're like, well, how do I know? This could be 10 years ago, but just if you can, try. Additionally, it's unclear, but these laws, they might be challenged in federal court, as just kind of the state of California is voiding legal contracts simply due to an employee's relocation. However, just out of an abundance of caution, we suggest that you comply with current law. Also, just there's some rumblings out there that under the Biden administration, they're talking about also possibly banning non-competes. It's unclear if there's an appetite, but it's just something to kind of keep your eye on. Okay. All right. So this next one, SB 497, it creates a rebuttable presumption of retaliation if an adverse action is taken against an employee within 90 days of the employee engaging in certain activities. Just to clarify, an adverse employment action, it includes like demotions, suspensions, and discharges within 90 days of an employee making like certain complaints. These complaints can be a missed meal period or rest period or equal pay violations, which can be them saying, you know, I'm not getting paid as much as my peer. The complaint does not have to be an actual filing. It can be written or oral. So, you know, a lot of people don't understand, but just that conversation, hey, I don't like that so-and-so is making more money than me, could potentially be under one of these complaints. This law is also significant because it now means that if those complaints do happen within those 90 days and you do engage in an adverse action against the employee, you're going to have to, the employer is going to have to rebut the presumption of retaliation. So with that in mind, just out of an abundance of caution, we say that to the extent HR procedures are in place, make sure that you've like added complaints to any potential checklist, like when you're moving forward with an adverse action of some sort. You know, that way you just also have complaint, like, okay, this time they did complain on this day, and see if it's kind of in that 90-day window. Additionally, it also expands the penalties under the whistleblower penalties. It used to be that, you know, it was $10,000 per violation. Under the new law, it is now $10,000 per employee, up to $10,000 per employee. Okay. Okay. So SB 553, this basically says that by July 1st, 2024, it requires most employers to implement a written workplace violence prevention plan that is easily accessible to employees. This bill excludes employers that are already covered, like under Cal OSHA violence prevention in healthcare, teleworkers outside of the employer's control, and work locations that are not open to the public and have less than 10 employees. Just so you know, workplace violence is defined as any act of violence or threat of violence that occurs in the place of employment. This includes oral and written threats of violence and incidents involving firearms or dangerous weapons, regardless of whether anyone is injured. The plan must be in writing and easily accessible to all employees. Some of the key things for the plan include procedures for responding to workplace violence, ensuring employee compliance with the plan, identifying and evaluating workplace risk factors. Also, this bill has a log and records retention requirement. Employers are required to log every workplace violence incident and retain the records for 5 years. So it's just, you know, and it's a very broad definition, right? So whatever little incident possibly, you know, is happening in the workplace, not only do you have to document it, but you have to keep it for 5 years. Additionally, this bill also allows union representatives to seek a temporary restraining order on behalf of an employee. Before it was just the employer, now it can be the union rep. The employee can also opt out of being named in the TRO, and the employer can still pursue it. Okay.
So there's also been some changes to minimum wage. And I just want to say before I go into this, like those of you, I'm so excited to see the Q&A. It's exploding. I was trying to quickly read through them while Asha was talking, and hopefully we'll get to all your questions. You guys are asking some really, really great ones, but I think probably we'll just try to table them to the end to the extent we haven't already covered them. So the state minimum wage is going up to $16 an hour starting January 1. And I think the important thing to kind of remember here as we go into kind of just generally speaking about the state minimum wage is that keep in mind that there's also quite a few local minimum wage ordinances. So if with the $16 an hour, where that really comes into play is if not only if you have an hourly worker and you don't have a local jurisdiction that has a higher minimum wage, that's obviously what you have to pay. But the other thing that is important to kind of think about is for those of you that have exempt employees, you also need to have a minimum salary basis. And that's based on a full-time employee making substantially more than if they were to do the math, substantially more than $16 an hour. And remembering off the cuff, I believe it's 1.5 times. But don't quote me on that one because I'm pulling that from the memory bank. But I want to really caution everyone here in California to be thinking about local ordinances because there are a ton of local ordinances that have a higher minimum wage. So for example, in San Francisco, it is over $18 right now. San Diego, it's $16.85. And the other thing that's really tricky about local minimum wages is that some of them are on an annual cycle, such as this, January 1, and some of them are not. So for example, both LA County and San Francisco, they experience increases typically on July 1st. So just something to be mindful to make sure that you're paying your employees the exact amount that you need to be paying them. Additionally, now we have, 2 additional categories on the state level requiring certain employees to make an even higher minimum wage. And one of the ones that's really making big news is the fast food workers. So what that means is that if someone is working in a fast food establishment, how they define fast food establishment is something that has at least 60 locations nationally that have, similar branding. So, the classic, the classic roadside fast food places that we all know well, Burger King, McDonald's, things of that nature, but the threshold is 60. And so as the law is drafted, it implies that, for example, if you're a franchisor and you don't have 60 locations under your belt, you still need to comply with this law if you're connected with a network that has at least 60 fast food establishments. And this increase happens on April 1st of this coming year. And it means that if you are an employer of fast food workers, you need to pay them $20 an hour. This amount is going to be increasing on an annual basis through 2029. And it's either going to be capped at 3.5% or based on the federal standard for urban wage earners. So it's really something like whichever is the lower amount is what is going to carry the day. And so on an annual basis, for those of you that have fast food employees, it's not going to be a set standard where we can perfectly give you a chart now. It's going to be something that is calibrated on an annual basis. And that's going to be issued by something called the Fast Food Council. And this council is going to be in existence through 2029, at which point it will sunset. Now, this law, for those of you that are in this industry, this space, I want to make sure you know that it repeals the Fast Recovery Act, or rather the Fast Food Recovery Act, which would have made the hourly wage $22 an hour. So that completely repeals that law and puts in this new structure where we're now starting at $20 an hour in this year, and then it will increase on an annual basis through 2029. There are some important exemptions, and I think the 2 that are really worth noting are if you're a fast food establishment that's located inside a grocery store, So for example, like a Subway inside a grocery store, then you and the Subway is owned by the grocery store, and is these employees that work there are paid by the grocery store, then this particular law is not going to apply. Likewise, there's a carve out for bakeries. So if an establishment is baking bread and is actually selling the bread, not, baking bread so they can make sandwiches, for example, then there could be a carve out where they also do not need to comply with this new law, even if they have the other trappings of a fast food establishment. If you think you fall under one of these exemptions, I certainly recommend you talk to a lawyer to determine whether or not you can safely not pay your employees the $20 an hour, but follow the applicable minimum wage. Additionally, there's been an increase for healthcare workers. There's quite a bit of range. This is going to go into place on June 1st of this coming year. And the range for this is between $18 and $23 an hour. And frankly, there's quite a bit of nuances. When we're looking at physician groups that are have at least 25 plus physicians, then it's going to start at $21 an hour in this year and then increase at 2-year intervals. So by 2028, employees will be making $25 an hour. Now, if you're part of a large health system, a physician group that's part of a large health system, so let's say you're a physician group and you're part of Sutter or you're part of UCSF, and those health systems have more than 10,000 workers or dialysis clinics, then the structure is going to be different. It's going to be starting you off at 23 in 2024, and by 2026, making $25 an hour. There's also a different standard for community clinics, and that is a $21 start in 2024, going up to $25 in 2028. And then hospitals that have a mix of Medi-Cal and Medicare patients and are, as well as rural independent hospitals, they have a lower threshold of $18 an hour in 2024. And those are going to be annually increasing by 3.5% until it reaches $25 by 2023. So needless to say, as I go through all those numbers, there is quite a bit of nuance in the healthcare space. So once again, certainly recommend that you communicate with your legal counsel to figure out what's applicable to you. Now, I want to make sure that we take a moment to kind of really think about like handbook revisions and updates. So this is for me a little bit of just speaking from the heart. Who says, how many people are like, they love handbooks? Raise your hand. Now it's not maybe the most exciting topic, but I can't emphasize enough how much routine cadence and maintenance of your handbook is really an essential component of both risk mitigation and legal compliance, but also on the flip side, making sure that your employees and your HR team is really armed with what are the expectations and standards. And in a place like California, I can't remember a year that didn't have new laws that changed at least one policy in the handbook. So how the typical cadence works, if putting COVID aside, when everything got turned on its head and we were making laws that changed yesterday, even though the law came out today, the typical cadence is that the bills that have been passed by the legislature here in California end up on our governor's desk by the end of September, early October. And is at that point, the governor has to sign those particular bills and make them into law. And then most of the time, the absolute earliest that the law will then go into place or become effective, if you will, is January 1. So the ideal time to be making handbook updates and reviewing your handbook is in this kind of like last quarter of the year so that you're ready to start fresh in January. Of course, this is something that we can help you with. Our philosophy is that it's really important that you have a base core handbook that is really solid, which enables you to make small adjustments on an annual basis rather than each year reinventing the wheel to ensure that you have compliance. And then additionally, this book is just so important because this is the number one most important exhibit when you're in any type of litigation, whether that is a big wage and hour class action, whether that is, someone's come forward with harassment or discrimination. This is going to be the exhibit that is front and center and needs to make sure it adequately reflects the law. So feel free to reach out to us and we can help you navigate this process, whether it's like, I need to start over, I need to start fresh, we haven't done a handbook in years, or it's, we did this last year and I just want to make sure that we have a good process in place. Happy to help. So now there's been quite a few questions and we want to make sure that we try to answer them as best we can. And Asha and I will kind of triage these questions. There's a couple that I've noticed about some of the topics that I covered. And I want to encourage you as you kind of sit here to continue to look at the Q&A box, fill out questions. And then of course, if there's anything that you just are like, I really have some questions that I have to think about, like I need to go talk to somebody, feel free to send an email to us, legalupdates@medinamckelvey.com, or of course you can always call our office line and one of our attorneys can speak with you. I want to talk first, when I was breezing through those questions, and I want to talk first about just the kind of paid sick and reproductive loss when we're talking about doctor's notes, because that was one of the questions that came up. So for paid sick, you cannot ask for a doctor's note for someone exercising paid sick until it triggers over into something that it either, it appears that there's been some kind of abuse. So someone, for example, says they've been out sick, but then you see them on social media at a Giants game, things of that nature. Or they've now, used their annual maximum and it's now time to kick it over to FMLA, CFRA, things of that nature. So how that's going to impact you on, and from a practical perspective, is that threshold used to be 3 days because that was the most that you could take on an annual basis. Our reading of the statute is that it now likely is going to be 5 days until you can ask for a doctor's note because of this increase. Now, for reproductive loss, you may not ask for a doctor's note for that particular scenario. So if somebody, for example, experiences a miscarriage, you cannot ask for a doctor's note. If somebody has a failed embryo transfer, you cannot ask for a doctor's note. It's written into the law. And there was another question about reproductive loss that I want to make sure we cover, which was, what if the employee is not the person who physically experiences the reproductive loss, but rather it's their partner that doesn't work for you? So let's go with that miscarriage example. So somebody's partner outside of work experiences a miscarriage. You have to also give the leave to the employee, even though the employee didn't experience the miscarriage, because the employee, under the rubric of the law, experienced a reproductive loss. Because with the rubric of the law, and there's numerous nuances, and like I said, it's a really, really wide range. So it's, loss of surrogacy, failed embryo transfer, failed adoption, breach of contract for a surrogacy arrangement, as well as, a miscarriage or something of that nature. The rubric for the law is, was this person supposed to be a parent? And because of some type of loss, they are no longer going to be a parent. And so that would certainly include employees that physically did not experience the reproductive loss. So, so if that person is your employee and they are the non-birth parent, but they've experienced reproductive loss, then you certainly do need to give them that time. And if they take that time, it's their choice whether or not to take it as unpaid or to use their available vacation and sick. You cannot require that they use vacation and sick in order to to use this time. I do encourage you to make sure that they know that that's available to them so that they can exercise that within their discretion. Asha, were there any questions that that you saw that we should cover?
I'm going through it now.
Mm.
Well, one, just to clarify, this is California law. I know that was one question. So everything that we're talking about is only applicable in California.
Mm-hmm.
There's some cannabis questions. Are you?
Sure. Do you want to, there's so many questions that let's kind of work together to try to tackle them. One of the ones I did see about cannabis was, what about people that work safety equipment? So, I'll share with you one of the things that I was kind of musing over. It's like, okay, well, what about somebody that is, in the lumber industry and is up in a tree and has a giant chainsaw? Like, is there a exemption there? So I think the real key thing for you is that if you think that there is not a carve out within this particular law for if you are using safety equipment, that then you don't have to apply. Rather, what you need to do is see if it's outside the construction trade and building trade, then it's going to be, okay, is there another law that warrants more aggressive testing that I can apply? And that's going to involve some, unique analysis that's individualized to you. Is there something else that you saw, Asha, about cannabis?
So about cannabis.
Cannabis testing, you were saying?
Huh?
You were saying you saw some questions about cannabis testing?
Yeah, I mean, there's one of just the different methods.
Oh, and thank you, Kimberly, who commented it's 2 times the minimum wage. Thank you for correcting me from my the recesses of my brain. I appreciate it. Thank you so much. And there was also a question about the fast food locations in the 60. The question is, it's nationally. So you could have one location in California and 59 in other states, and this law would apply. It is a national standard when we're actually counting up the 60.
Looking just to see.
And for those of you that do have exempt employees, it's now thanks again for Kimberly who put the math in the chat here rather than the Q&A. It's 66,560 according to Kimberly's math. So thanks again, Kimberly. You're like, I should have had you as a panelist. And that in order to have your minimum threshold.
So one thing I'm seeing a lot just regarding the cannabis thing is like people asking, what about like specific professions? And I think you kind of gave that caveat, like there are certain like the DOT and all these things that do have it. I see one asking about medical and dental workers, mechanics. Chantelle can probably talk more to that, but I think this is where we would refer you to that specific industry and what those standards are. Yeah, Chantelle, do you want to?
I agree. Like, I think that the part of this is going to be very, very nuanced. And so the question that you have to ask yourself, if you have an existing drug policy, is why do I have that policy? Is it because of a practice? Is it because of a particular law that enabled you to do it? And frankly, if you're not quite sure, and you're worried that this new law may apply and you don't want to make a change, it's all the more reason to talk to counsel to try to figure out if there's an exemption that you can trigger. And something else that just kind of came up that I think is really important that we talk about is handbooks and whether or not you should have your employees sign a handbook. Without exception, I can't think of a reason why you would not have your employees sign an acknowledgement of the handbook. And in my kind of way of thinking is that it's not enough to just say, I got this handbook. There really needs to be in there an acknowledgement that they've not only received it, but they understand that it's their responsibility to review this handbook and to adhere to the policies. And while it doesn't change their at-will employment status, in essence, like these are the rules of the game. And I know that if I want to play the game here and I want to be an employee here, I need to follow these rules. This is incredibly important when you have somebody who then violates a policy. Likewise, it's also incredibly important when you're trying to educate people on how to come forward with complaints and concerns about policy violations. It's like, well, I didn't know that wasn't allowed. I didn't know that you didn't tolerate bullying. Like, but if it's in the handbook and they promise to read it, you're going to be in a much, much better place. So I certainly recommend that, that's something that you do. Additionally, if depending on what your workplace is, it may be something that you want to publicize the updates, depending on if you think that it could be something that is like, a benefit to your employees, or something where even though it's legally required, it's something that you really want to educate your employees about their ability to exercise this benefit. I think reproductive loss is a really good example of that, because it's going to hopefully impact a small portion of your population. Hopefully it's outside the norm. However, it really kind of can foster a culture of support and engagement, and inclusivity, that even though you have to do it because it's legally required, it really helps kind of bolster your culture. Speaking of reproductive rights, I saw a question about surrogates. So as it's written, I would think that if a surrogate experiences the loss, so actual physical loss, that would be an example of probably something that falls under this potentially. If it is the breach of contract, for example, like they were going to enter into a contract to be a surrogate parent, that would not qualify at all, because they were not intended to be the actual parent. So in reality, I think really when that's a kind of an unusual situation. I think that more often than not, it's probably going to be that the surrogate is really falling under additional types of leaves, such as like disability due to recovery from a loss or things of that nature, because they don't intend to be the parent. So I need to take a closer look at the law, but my instinct is probably they are excluded.
And then I saw one question asking about the workplace violence prevention plans. Somebody asked if there would be a template available. There isn't one now we don't know anything about, but we anticipate that Cal OSHA will give some sort of guidance regarding that. So, I think, if we can, we'll possibly post a link if it becomes available or anything, because they tend to also just give guidance on things. Additionally, there was another question asking about non-compete agreements. Are they different from NDAs? Yes. Yes.
Yeah.
Non-compete, again, they're not really common in California. This is out of state, but non-compete, and Chantelle can also speak to this, but it's basically you're not going to compete with the business, whereas an NDA is, secrets and other things within the business.
Mm-hmm. Yeah. The way to kind of think about this new non-compete law is that non-competes have been impermissible in California for quite some time. And the kind of philosophy behind this is that the state of California has come out and says, we do not want to infringe on people's ability to work. And so unlike other states that say, hey, for the next 6 months, a year, you can't do this particular job, or 2 years, as a very general matter, that's prohibited in California. There are obviously some exceptions to that. So if it's something that you think is appropriate, a non-compete would be appropriate in your particular situation in California, we should chat. But really what this law is saying, I know you did this in another state, but now you're here in California and we're not going to enforce those contracts. Another a question that came up was about the reproductive leave. And the window here is 3 months. And the question is like, well, do they have to tell us that it happened right when it happened, or can they tell us retroactively? And the law doesn't really address that. But I think from a practical matter, as long as they're telling you within that 3-month window, then that should be enough, because they don't need a doctor's note to prove it. And when they want to exercise the time, as long as it's within the permissible 3-month window, then they should be permitted to exercise that time. looking to see if there's some other ones that we can tackle. Oh, so this is a little bit off topic, but I think that this is kind of an interesting question. It's like, all right, well, what's the update on arbitration agreements? So there has not been any new legislation regarding arbitration's permissibility in California. As some of you may know, there was a law that was passed and in essence has been nullified, limiting the scope of arbitration agreements in California in the employment context. However, there has been quite a bit of case law over the last year and a half, 2 years regarding arbitration agreements and whether or not they are permissible, including some federal case law that made it a lot more clear that having a compulsory arbitration agreement is, as long as various other boxes are checked, is something that could be defensible, whereas that had been a little bit of an open question prior to that Ninth Circuit case that came out last year. And so the long and the short of it is that arbitration agreements are permissible. Having an arbitration agreement that is completely voluntary by the employees is going to put you in a much better place in terms of its enforceability. But involuntary ones, meaning like you have to sign it, are also permissible in certain circumstances. However, because of this evolving case law, the two things to keep in mind is that there is very specific language that needs to go into an arbitration agreement. And this is certainly something that we can help you with. This is something that we have litigated, that we have a template that we've put before mediators and before the courts, and have gotten the seal of approval that these are, valid and enforceable. And so we can help you in this regard to make sure that you have kind of all the bells and whistles. And then my second comment about that is, the law is evolving in this space. And if you have arbitration agreements, this isn't something that you can just really sit on. It's something that you really need to be kind of plugged into the evolving kind of nature of those types of agreements in California. So we have a couple more minutes. And so, Asha, we got a question that says, employees, does it make sense to have them re-sign the handbook every time we update it? So what do you think about that when there's just been an update? Do you think that they need to re-sign that as well?
Yes, I would say so.
And what should you do? Like, do you have any tips about what you should do if somebody just says, like, I'm not going to sign the handbook, I'm not going to sign the acknowledgement?
Well, I wouldn't recommend you force it, or recommendations. I wouldn't say you have to sign.
Mm-hmm.
Yeah, I would encourage them. It's an acknowledgement. Chantelle?
I think that it's worthwhile to have a discussion with them about why they won't sign. Because once again, what I was saying earlier, like, this is the rules. Like, why are you not willing to understand what our rules and expectations are? Like, it actually could be potentially a performance issue with the employee if they're refusing to acknowledge the handbook. I mean, maybe they say like, well, I don't want to sign it because I want to read the whole thing and I don't want to sign it till then. It's like, well, super. Like, we'll check back. How much time do you need to read it? How can I set aside time on your calendar? Do you want to read it cover to cover? Like, there's a way, as Asha said, you don't need to be like, you need to sign this. That is not effective.
You want that.
One person's going to say like, I was forced. But you want to make sure that you are removing any obstacles that are getting in the way of them signing it. And if they can't articulate obstacles that are getting in the way of the signing it, then it really could be becoming a performance issue, because this is somebody that is in essence unwilling to learn the rules of their employer,
which could create a problem for the environment.
For sure. And then there was also kind of a related question about, an electronic acknowledgement. Absolutely fine. There's been great case law in recent years that e-signatures are permissible. My only recommendation on that front, and this is simply because I've litigated this, it needs to be a a secure e-signature with a proper audit trail. So there's a multitude of platforms. Adobe has it, DocuSign has it. Like I don't have a, a preferred provider. But I have seen people that say like, well, it's an e-signature because they had the person like in a Word document type in their name. Like that involves a little bit too much ambiguity regarding whether or not this was an actual signature, who had access to type in the person's name. So you want to make sure that you're using something that really does a secured signature. But that's certainly something that you can do, and frankly is makes life easy. But to kind of Asha's point, that you don't want to force people. So if you're pushing out updates electronically and asking people to sign, keep tabs on whether or not people have signed it. And you may get quite a few people that haven't signed it right away because they want to take a time to like open it, look at it. And if possible, I even recommend that they have it so they have to open the document before they can sign it. They can't just like sign an email like, yep, I got it, I acknowledge it. You really want that like kind of an extra step in the electronic environment versus like doing an old school where you hand them that handbook and say, okay, I know you're going to read through this, it's your first day, and having them do a wet signature. That said, old school way works just fine, and if that's what your process is, stick with it. And then there's one other question about handbooks, and I think we'll leave with this. And I know some of you may have some questions that you haven't had answered, but we certainly will look at all the questions and circle back with you. The question is an employer required to translate the handbook into different languages? And the short answer to that is yes. And really what we're looking at is a 10% threshold. So if you have 10% of your population has a particular language, then you're going to want to translate it into that language. And the way to kind of think about this, where you're like, well, what if I work somewhere and like, there's a bunch of people that speak multiple languages, like, it's they're fluent in both Spanish and English. Like, if they speak Spanish, but they fluently speak English, do I have to translate it? You think about what is the language they are using at work? So, for example, I had an employer where people were able to speak English. They were required to speak English when they were communicating with customers, but their manager was engaging with them in Mandarin. And so they were getting instructions in Mandarin. So because of that, I would argue that your safest bet is, because they are receiving instruction and feedback in Mandarin as well as in English, that you should have both options. And it should be made very clear to employees if they want something translated, and ideally if you can present that to them in their language, to say, if you'd like this translated into insert non-English language, we'd be happy to do so. That's a great acknowledgement, especially if they say, no, I'm fine, I understand English, it's great. That's once again back to the evidence piece. That's a great piece of evidence. So I just want to thank all of you. Asha and I are so thankful for you tuning in today, as well as just your high engagement with all these questions. This has been a really great conversation, and we hope to continue the conversation as time goes on. Feel free to reach out to any of us, whether it's through that legal updates email, through our emails. All our information's on the website. And good luck with your legal compliance in 2024.